The way they presented the text messages would have been from our client's phone, as if our client was the tipster, which wouldn't make any sense. Like my client was not tipping the DEA to himself. And so it became very clear that these were intercepted, and then they were using the guise of that tip to then get the whole search warrant in the case. The whole case was almost completely based on those particular messages.
Welcome to the Liberty Lawyer Podcast. I'm your host, Nick Somberg. This podcast is about your constitutional rights, cases where I fought the government and won. We have great attorneys on that have fought the government and won and stood up to protect people's rights. Today on the show, we have renowned attorney David Rudoi. And this is a good friend of mine, somebody who's been practicing a little bit longer than me, who is a mentor of mine. And he actually has had 3 Michigan Supreme Court cases, 2 of them having to do with marijuana victories. He's been fighting the good fight for marijuana legalization for a long time. David, thank you for coming on the show.
Thanks for having me. Happy to be here.
Absolutely. So we had a really big case together. It was touted by Oakland County Sheriff as the largest marijuana bust and therefore the largest marijuana dismissal in Oakland County history. And we knocked that one out of the park. But before we get into that, I would like to know more about your Michigan Supreme Court cases regarding marijuana, and tell us about your first one and what did you win?
Okay, so my first case was a case where I was defending the wife of somebody who was a medical marijuana caregiver, and her husband came upstairs. He was working on the plans. He had they call it finger hash, which is essentially when you're working on plants, your hands get all sticky from all the trichomes from the marijuana. And so he's like, how do you think, because there's this issue in the law of usable marijuana. You're allowed 2.5 ounces of usable marijuana per patient. He's like, how do you think I show what's still drying and what's curing and what's usable and show what the harvest date? And so my client basically was like, why don't you just write it on a sticky note, like the harvest date and when it's going to be usable? So then you could and this is very early on when none of these rules were really known. So she wrote that down on a sticky note with the intention of helping him comply with the law. Oakland County Sheriff's net team busts in there and they ask him who wrote that down. And he mentioned that his wife did, or somehow, I can't remember exactly, but they found out that she was the one who wrote that down. And they charged her with a conspiracy, conspiracy, which means an agreement between 2 people to break the law. So one of my arguments, of course, was that she didn't agree to break any law. She was trying to help him comply with the law. But I actually found under the Michigan Medical Marijuana Act, you're allowed to provide paraphernalia to anybody who is a medical marijuana patient or caregiver, and you're immune for doing so. And so I made kind of a novel argument that the sticky note itself was paraphernalia, which means anything that's meant and used in the manufacture or use of a drug. And so I made this argument that, in fact, the sticky note, if they were going to use it against her and say it was used to help grow the marijuana, then it was, in fact, paraphernalia. So the Michigan Supreme Court found that it was paraphernalia, and she was immune for giving it to her husband, and therefore her charges they remanded it back down to the lower court, but without that piece of evidence, their case was screwed, and the charges ended up getting dismissed.
That's brilliant. And so what precedent did that set?
So essentially, the precedent that set, which can still be used today in this context, is essentially that anything, so when it comes to paraphernalia in the normal sense, you buy rolling papers at the store, or you buy a hypodermic needle because marijuana is legal now. But if you bought a hypodermic needle, that it has to be specifically designed under the normal statute for the use of drugs. So since a hypodermic needle or a pack of rolling papers or a bong could be used for tobacco or something that's a legal substance, stores are still allowed to sell that stuff. But in the context of the Michigan Medical Marijuana Act, what it means is that anything that is used, So if a caregiver or patient asks you to go get them anything at all related to their medical marijuana growing, use, consumption, manufacture, anything from the process, from the seed all the way to ingesting it in your body, anything that you provide that person, you're immune. And it doesn't matter if that person was qualifying under the act or not, as long as they had a card, as long as they were in fact a patient or were in fact a caregiver, where other provisions of the act, whether or not they were complying with the law matters, but in this context, it doesn't. So people have used this case to argue that like providing grow equipment or paying the electricity or providing them a place to grow. Now all of these things are, because like a place to grow is actually paraphernalia of growing, because it's anything that's used to help
the building
the
can
grow.
be paraphernalia.
Correct. Under that statute.
Well, that makes a lot of sense.
So essentially it protected everybody who wants to like interact. You don't have to be afraid to like interact or help them in any way that you're going to get tied into this criminal conspiracy. The second case was a case I did with Sean Myers, who I think you've had on your podcast or will be coming on soon.
He was on the case with that we were on.
Yeah, he was on the case that we were on. He was also on this other case. And essentially what that case was about was the cops show up at a house and the guy's like, they're like, we think you're growing weed. And he's like, yeah, I have medical marijuana cards and everything's legal in there. And then they still bust down the door, go search the place, raid everything, take everything. And we're saying, and so the argument in that case was essentially that there's no probable cause, and that the probable cause of growing marijuana alone, when they were presented with information that the marijuana growing was in compliance with the law, at that point, the probable cause is dispelled. They have to go back to the magistrate and with the new information, seek a new warrant because the material facts in the search warrant have changed.
So the police, they showed up with a warrant.
Correct.
And the person answered the door, says, hey, I have medical marijuana cards. I'm allowed to be doing what you're even accusing me of doing. And they had no evidence that they were above any sort of limits, breaking any laws. And the police just executed the search warrant anyway.
Correct.
And I assume they took all of their property.
Yep, they took all the property, they raided, they charged with a bunch of felonies. And it was Sean's case in the trial court. I came in to do the appeal. And you know, we had a really good record that not only, so he told them all the necessary elements that he was immune under the Michigan Medical Marijuana Act. And so what the status of the law kind of currently is they don't have to investigate whether you would be immune, but once they're presented with that information, they can't just keep going forward.
And the client and the person knew that, or he just naturally said that off the bat? Like he just happened to say the exact right thing.
Well, he wanted to tell them how he was compliant with the law. Yes. He didn't want his house to be searched. So sure. I think he just, in this sense, kind of lucked into saying the right things.
And people, I mean, how many marijuana cases would you say you've represented?
I'm probably in the hundreds.
Yes.
Maybe nearing 1,000. And
for when they raid somebody, I mean, this is not a good experience. They destroy people's homes.
Yeah. So I'm happy that the Medical Marijuana Act happened, but the Medical Marijuana Act really ruined some people's lives because people that were attempting to comply with the law. So they get these cards. The card says you're allowed to grow marijuana. And then the courts have really restrictively read, like really strict, like, in every sense of the word. And then they find if you're outside the act in any version, like, so the law, just for an example, the law says that a locked and enclosed facility is a facility that prevents access between, from anybody besides a patient or a caregiver, uses the term a. And then the courts started to just rule that means nobody besides the caregiver can enter that house. Or enter that room. So if like they broke into a house and the door's unlocked, and they're like, well, it wasn't preventing your wife from entering that room, so you're outside of the protections and we're going to arrest you. And the other thing that was like am I allowed to swear on here?
Yeah, of course.
So fucked up is like they give you a license to grow marijuana. They're like, you're immune for growing plants in your house. And then the cops would come by and be like, I smell weed. Let's go get a search warrant. Now, that's all they needed because they had no duty to investigate whether it could be compliant sale. And so then next thing you know, Oakland County Net or whatever, like narcotics enforcement team, bust down the door, raid the house, put guns to like your kids' heads, basically, tell everybody, get on the fucking floor, get on the floor, scare the shit out of everybody, arrest everybody. And then they, under civil forfeiture statutes, would take like all the cars, all the property worth anything in the house, basically hold it hostage, prove it guilty until proven innocent, as far as the civil forfeiture part of the case, all because you decided to get a card. And then essentially we were forced as attorneys to go in there and say, no, they're complying with the law. But there, in the meantime, even when we won, in many cases, you know, multiple cases that we've had, even when we win, it's like they were subject to their door being broken down, like their kids having PTSD from this whole thing, their property taken, and usually they want their property back. So rather than fight it out, it's usually kind of like, okay, we'll settle for $5,000 and we'll give you your 3 cars back. And then they had to hire us. When all they were trying to do is like be compliant with the law in Michigan, and they never would have even started growing weed had there not been a card that you're immune for doing it.
And so the government sort of gave them a license to grow a harmless plant, and the government then uses it as a pretext to raid people's houses, really steal their property, and then sell it back to them. And you brought up civil asset forfeiture, so I think that's one of the most evil things out there. It is a violation of the beyond the reasonable doubt standard. It's also a violation of innocent till proven guilty. And the government essentially can raid somebody, not even charge them with a crime, and take your car. They do this to poor people in Detroit to say, hey, we don't like something you're doing. We're going to take your $1,000 car. And then they don't have the burden of proving that you committed a crime beyond a reasonable doubt. You have the burden of proving that your vehicle or whatever it was, that money, was not involved in a crime by clear and convincing evidence. So it turns it on its head and changes the burden of proof. We make that you have to prove yourself now innocent to get your property back. And most people, it's like there's this area where it's not worth it. It's not worth hiring a lawyer to fight it. And people just end up buying their stuff back from the government. And then they're found out not guilty or not even charged.
Yeah, it's so just to clear something up, we did have some civil forfeiture reform in Michigan in the last couple of years, where now they can't see, there has to be a criminal conviction first. So now how it kind of works is they take all your property and they wait to see what happens with the criminal case. And if we win the criminal case, we get the stuff back.
But you can sign. But a lot of people, I've had people get raided and they sign a forfeiture.
Yeah. Oh yeah.
And then their stuff's gone.
I mean, exactly. What generally happens is, although they've improved it a little bit, they bust in, they take all your stuff, and then they know, like, pretty much any lawyer to fight a civil forfeiture case that's like a civil attorney, they're going to be charging hourly. If you get anybody good, it's hundreds of dollars per hour. And just the amount of hours that it takes to do a case like that, $5,000's kind of like, there's almost no way you're going to fight a civil forfeiture case for less than $5,000. And it could be like $50,000 or $100,000 if you go to trial and go through the whole thing. And so the government's really good at knowing that and being like, we'll give you all your stuff back for $5,000. Right. It's like, would you rather pay a lawyer and maybe get your stuff back and maybe spend more, or pay the government $5,000 and definitely get your stuff back? And unless they're rich enough to fight for what's right, which a lot of our clients don't have the money to just spend $50,000 because it's what's right, they need their stuff back, so they spend the $5,000 and basically pay for their own.
The proceeds go to the department.
That's right.
So it's not like this is going into some, victim fund or something to help, domestic violence victims or just property crime victims, that the police actually get to keep your car or your PlayStation or your guns and your money. And it goes to the department itself. And I just find that it's such a conflict of interest.
Well, yeah. I mean, I just had a case. It just brings up a case. Sanilac County, a very specific Sanilac County, and maybe I won't name any names, but maybe the city where you find the Sanilac County Courthouse, the police chief there's an article about how he needs more guns. And then all of a sudden in a marijuana case, they seize all these guns from my client's house. They don't let me ever look at the search warrant. And then they're willing to dismiss all these felony charges if we'll settle the civil forfeiture case. So they use it as a bargaining chip. They hold these felony charges over your head, and then they're like, just give us some guns. We'll give it everything back. And so, I mean, it's a crazy practice. It creates a complete conflict of interest where the police they're interested in getting money for their department, not necessarily enforcing the laws that harm the public the most. They're interested in enforcing the laws that pay them the most, which during the whole marijuana boom, since 2008 was marijuana people. Because guess what? It's really easy to smell weed outside of a grow and then raid the place and take all their property and let them prove that they didn't get it from marijuana proceeds.
Now, I know you also do a lot of OWI cases in Michigan, and it never sat well with me that it's considered an OWI to have used marijuana in the last 24 hours. So you could eat dinner the night before, you could smoke some weed before bed, go to bed, wake up, have lunch, have breakfast, have lunch, and get pulled over for not using your turn signal. And a lot of people are foolish enough, maybe their car smells like marijuana, and they say, oh, well, yeah, I smoked last night, thinking that that's okay. And the officer will pull them out and do a field sobriety test and ultimately get their blood and find a couple nanograms of active THC. And that's considered an OWI. Same if you're just had 5 beers at the bar and got in your car and drove, and it's the same thing. Tell me, how do you fight those cases? And what's the difference between somebody who has their medical marijuana card and somebody who doesn't in that circumstance?
So, first of all, it's my favorite type of case to fight because it's the intersection of the two areas of law that I do the most, which is marijuana and drunk driving law, or driving under the influence law. I have not pled anybody guilty for driving under the influence of marijuana since we legalized cannabis. There used to be a difference between medical and recreational marijuana use in this sense, but it is gone because of the Michigan Regulation and Taxation of Marijuana Act, which we copied. I helped write. We copied the language from the court opinion of People v. Kuhn, which says that you're immune for internal possession, and only if you are operating the vehicle under the influence. So now the police have to prove that you were under the influence.
Yes.
So what does that mean? Well, having some in your system is certainly evidence that you could be under the influence, but they generally, the way the law works now, they really have to prove that it affected your ability to drive in some way. And so, we had just had a really big win on this issue. There was something called the drug recognition evaluation, which was bullshit voodoo science, where they're like, they do this thing where they put their finger in a circle and see if you can cross your eyes. And if you can't cross your eyes, you're high, because high people can't cross their eyes, which is total fucking bullshit. It's made up. I've personally tried this field sobriety test on hundreds of people high on marijuana. I've never seen one person that smoked weed that can't cross their eyes. So what's really going on is it's uncomfortable to cross your eyes all the way down to your nose. So they do this thing, they go in a circle and they put their finger all the way up to your nose, right? And eventually crossing your eyes, you get uncomfortable and you stop crossing your eyes, right? Somebody's going closer to your nose, you cross a little bit and then you poke your eye back out because it doesn't feel good. Because your mom told you if you cross your eyes, they're going to get stuck that way, And then they're like, this guy's high, his eye button hooked. It's in every report. They also train them that smoking marijuana can leave you with a green tongue. Don't know where that came from. It's just basically total bullshit science. And recently we had a case in the Michigan Supreme Court. I wrote the amicus brief on behalf of the Michigan Association of OWI Attorneys, which for the audience is a friend of the court brief. So it wasn't my case. I just basically jumped on to give my opinions about it. But they said that drug recognition evaluation has no scientific accuracy at telling if somebody's under the influence of marijuana. But yeah, it is important for all the cannabis users in your audience to know that you are right. Any amount of active cannabis in your system, which if you take an edible could be 3-4 days. If you smoke it, could be 24 hours, depending on how much you smoked and your body's metabolism. And if you go out there, you get into a car accident or give the police some other reason, they're going to do these voodoo tests on you, say they believe you're under the influence, test your blood, and then charge you in court. And, unfortunately, you got to hire a good attorney who knows how to fight these cases because, and just to be clear, the studies show daily cannabis users drive better when they've used marijuana than when they haven't used marijuana. So the whole idea, of driving under the influence of drugs is kind of malarkey. Also, like, for example, amphetamines, like they'll charge you if you have Adderall in your system.
Yes.
Adderall makes people safer drivers.
Yeah, more concentrated.
No question. Yeah, exactly.
And
Cocaine also makes people, on average, safer drivers. Not that I'm recommending the use of cocaine, but, just saying, like, charging an OWI and saying you're endangering the public by driving in that manner is malarkey.
And this is government science. I call
government
it
science.
Government science, and they just come up with their rules, and then they declare that they're right, and it's very, very hard for them to realize that they've made a mistake in their logic and their science.
And they once they've convicted people, or like shut down businesses, talking about government science, like once they've taken these actions, it's very hard, I think, for the government to be like, oh, we were wrong. So it's a problem because the scientists, like, they act like they know, and then like a bunch of action gets taken that hurts people's lives. And now what are you going to do? Be like, oh, sorry, I was wrong.
Well, and federally, marijuana is still declared to have no medicinal purpose, and it's a Schedule 1?
Schedule 1, both in Michigan and federally.
So same schedule as heroin, as real drugs?
Same schedule as heroin, methamphetamine. No medical benefit, even though 29 states have voted to have medical marijuana acts or allow some medical use of marijuana in their state.
And Michigan's issuing cards.
Yeah.
So, I mean, this is a black and white hypocrisy that makes no sense at all. It is completely illogical.
It's insane. The amount of studies. So the government's classic line, or the FDA, which I think they are going to be changing this very soon, but their classic line is, we don't have enough science. There's not enough science on marijuana's medical use. And one of the reasons there wasn't a lot of science was because it was federally illegal to possess. So it's very difficult to get the grants to be able to study it. But also, there is a lot of science. So if you go to PubMed and look up studies on marijuana, you're going to find probably around 36,000 studies last time I looked. That these are peer-reviewed scientific studies about marijuana. So we'll talk about it. What's like another drug that we would think is really well studied? How about acetaminophen, Tylenol? 2,400 studies. So there's 15 times as many studies on marijuana. But nobody says there's not enough science on acetaminophen, but there's not enough science on marijuana. Luckily, the DEA did recommend rescheduling marijuana to Schedule 3, and it looks like it's going to be coming in 2025. Hopefully, if some, good people get into Congress, we can make sure that happens.
Yeah, if I was Attorney General, I would take very seriously the property crimes and the hurting people and stealing and fraud. But there are so many victimless crimes. And there's victimless crimes that affect poor people the most because they get in this endless snowball or domino effect of, oh, you committed this little victimless crime, and the plaintiff is the state of Michigan. You've affected the dignity of the state of Michigan for possessing cocaine. And then, okay, you lose your driver's license, but you got to
generally,
work.
whenever the people are
Yes.
the victim in
Yeah.
a case, it probably shouldn't be prosecuted.
If there's,
Not 100%, but
I agree. I'd say almost 100%. I mean, there's certain ones.
like DUI, maybe there's some gray area there. But I mean, I think there's an argument. If you haven't hurt anybody, have you done any harm?
I think,
you know?
honestly, I think the standard should be reckless. That if whether you're drunk or not, if you endangered somebody, even if you didn't hurt somebody, but like you could have,
You got a reckless disregard.
you're
for
reckless
human life.
disregard, whether you're drunk or not. But if you're a .09 and you're driving perfect,
Yeah.
and you just happen to or someone hits you, and then the officer's like, I smell alcohol on your breath.
And you did nothing wrong.
You did nothing
I
wrong.
agree.
There's no victim.
There's no reason for it per se. But yeah, I think it's actually interesting. I hope you win for Congress. But to have a libertarian in the highest law enforcement role is actually a place where you could probably affect more change for more people than in Congress.
It would be wild.
It really
would be wild being like, I'm in charge of all the police. That'd be awesome. And actually the good police, which is most of them, work with them every day. They love me. Like I think they see me as like a fellow America, fight for what's right, freedom. It's really some of these bad actors that don't like me.
Yeah.
And it's like they just can tell. I walk in the room, they just know that I'm on the good team. And by bad police, I mean police that civilly asset forfeiture poor people's cars, and break things and assault people and put AR-15s in the kids' faces and yell and scream over small amounts of drugs or marijuana. I also don't I'm a landlord in Pontiac, and I've reported real crimes like, hey, this person broke into my, project that we're working on and stole over $1,000 of things. And that's a real crime. And they call it a civil matter. I've never once reported a actual crime in my landlording that the police have been like, yes, sir, you pay all this money in property taxes. We're actually going to do something for you. And but if I said, hey, this guy, I think he might have cocaine in his car,
It'd be there.
they'd be like, get the SWAT team, track him down, get a warrant, put a tracker, maybe if they're lucky to get a warrant. But yeah, I am all for being tough on real crime and no more victimless crimes. It should be nationwide. We're beyond it. It's old school. It's like
the government is not here to be our parents, to tell us what we should be doing with our own bodies, right?
Yes.
If there's nobody else, if there's no victim, there should be no crime.
And drugs is the big one, right? So there's people that legitimately need help, that need that. Well, and we have a little bit of law. We have the Good Samaritan Act, where if you're using drugs with somebody and there's a perceived overdose, real or not, that you can call the police and nobody in the room can get in trouble for possession. So as long as there's not a kilo sitting on the table, nobody can get in trouble. But I think victimless crimes they hurt people's ability to resolve conflict and to seek protection. So prostitution, for example, not saying that that's a good, career to have or anything, but the reason that there is sex trafficking and pimping that goes on and men taking advantage of women and hurting people is because it's a black market. And
every time I always ask people when they're like, yeah, but you would, for example, I would legalize all drugs, right? Because they're all victimless crimes. And they're like, you would legalize fentanyl? Look at how many people it's killing. I was like, and my response is always, oh, because fentanyl's legal now.
Yeah, so I'm going to go do a bunch of fentanyl.
No, it's illegal. It's still killing everybody.
Right.
Why is it killing everybody? It's because we're not regulating anything. We're not advising people. They don't know what they're getting. They're buying cocaine. It's got fentanyl in it. Would there be fentanyl in the cocaine if the cocaine was legal? No. The deaths, the real harm caused by all of these drugs is in making it into a black market that's unregulated. Regulation, I think, is probably good in these areas. And not that I'm into government regulation too much, but having some regulation and control so that consumers have control of what they're getting would prevent all the harm.
Well, there's free market regulation as far as products liability.
Yeah.
So if you buy something,
if
you buy something, just at the store, you got adequate warning labels on it. You got ingredients, you got side effects, you got all this. So if you're an adult and you want to use a substance, I mean, the thing is that it's not a crime. that crime and like cages for human beings should be reserved for those that need to truly be separated from society because they're just hurting people and destroying property. And there can be some sort of maybe civil consequences, but to me, that there has to be a plaintiff. There has to be somebody on the other side of the V on the court document. There has to be somebody in court that says, that man harmed me. That man stole from me. And if there's not, I don't really care what it is, that if there's not somebody who can show up to court, and this is what our founding fathers also said, you have the right to face your accuser and cross-examine your accuser, that if no one can say that you harmed them or harmed their property, they're simply not a crime. And we're wasting tons of money and resources and ruining lives and taking fathers out of homes. And the effect is exponential. And it affects the poorer communities even more that sometimes can't afford a good lawyer or don't have the resources or don't even have the knowledge to even know what to look for or ask for. And people act out of fear and desperation, and they plead guilty to crimes that maybe they're not even necessarily guilty to.
And then they get put in a cage. We do have a big human caging problem. So
the United States has the highest incarceration rate in the world.
Yeah. And I mean, I just to reiterate, I mean, you hit the nail on the head. A cage is reserved for somebody who can't stop harming society, either persons or property. Yes. If we can't prevent them, they just keep wanting to steal or keep wanting to hurt people, then a cage should be reserved for those situations. It kind of makes sense. Like we can't stop them from harming them in any other way, so we're going to put them in a cage. But what these judges around here, they think that like a cage is like, well, I'm mad at you. You didn't follow my rules. I'm going to find you in contempt of court and put you in a cage for a little while where there's no victim. I mean, it's craziness. So
yeah, and also the cage doesn't make a victim whole. That a lot of times, if you stole my car and drove it off a cliff, okay, at least for me, I just want to be paid back for my car. I would like to have a new
force them to work at their job to pay you back rather than force them to sit at a cage.
See, that gets tricky because it's like, government forced work.
Slavery. Yeah, a little bit. But I mean, I guess my point is not force them to pay you back, garnish their wages, to pay you back, not necessarily. But like when you put somebody in a cage, it's antithetical to making you whole. It actually does the opposite.
Yes, it makes them unable to work, unable to provide.
Exactly.
I want to get into our case. Now, we had a huge marijuana dismissal. It was touted by Oakland County Sheriff as the largest marijuana bust and therefore dismissal in Oakland County, where they found over 413 pounds of marijuana, over 7,000 containers of marijuana wax, and 70 pounds of THC oil. And when we got the court, sounds pretty serious, right? Literally garbage bags full of weed. And it didn't even make it past the preliminary exam stage. There wasn't even probable cause to go forward. So myself, David, another attorney, Sean Myers, who couldn't be here today, we triple teamed this case. There's 3 different defendants, so each one of us had a lawyer. And this was a wild one. There was government overreach, some shady dealings, misuse of legal process, illegal Stingray, which we'll talk about a Stingray. So let's jump right into it. So this case was there's 3 good men, businessmen, families, had other jobs, other businesses, and allegedly were growing marijuana in this warehouse. Now, that warehouse was raided. There was civil asset forfeiture. I mean, the police, Oakland County Narcotics Enforcement Team, NET, destroyed their businesses, destroyed their lives, raided their houses, scared the crap out of their families, and ultimately on very flimsy evidence, which ended up with not even finding a probable cause by Pontiac District Court judge. So, David, I led the case. I got the case, and then I'm like, well, who's the best marijuana lawyers that I know that I'd like to team up with? So I called you, and I called Sean Myers, Cannabis Counsel, where I used to work before I was a lawyer. That's where I interned, and got the lay of the land, and became pretty good at marijuana defense myself. So you remember this case? This was 2018.
2018.
Pre-COVID.
This was a fun case. Cases are always the most fun when you get to work them with your friends. When we get to take turns cross-examining officers, there's nothing more fun. I'm never happier than going out to lunch to a Coney next to the Pontiac District Court with my two friends, like after we just eviscerated some cops and caught them in some lies on the stand.
And they were mad. Oh, they were mad. Like, we were feeling good. So it was a multiple day exam. And I just remember like going into like day 2 and like kind of teasing them like, I don't think you guys have anything. I'm like, I really think we're gonna get this. They're like all like bumbling angry. I don't know what this guy's problems are. Like, it's freaking weed. It's not like we're not defending some like child rapist. Like, they're acting so angry over like, okay, you guys found a bunch of a plant. You know, good job. You remember? So this was my largest marijuana case, you know, at the time and to date, and we actually got to see the evidence. So your attorney has the right to actually physically inspect evidence in any crime. And there's 2 parts to this. One, do you remember going to like the police's like stash house and there was garbage bags of weed?
Yeah, it's like a big garage.
Yes.
At an undetermined location that you don't get to know until right before.
Yes.
That was fun. Yeah.
And I have a picture of me like laying in like 5 garbage bags of weed. Which I don't know if they knew I took that or not, but, you know, they open up like a shipping container and there is like your Home Depot, like 60-gallon garbage bag. Like, what?
Just to correct you on one thing, they weren't using garbage bags. Guess what they were using?
What was it?
Body bags.
They were body bags.
Yep. They had extra body bags.
Wow.
So well, for the plants. So the finished flower, I think, was in garbage bags, but all of the plants, they were using body bags at that time.
Well,
which I think are pretty expensive, by the way.
Well, they got to use them. They got to use them for something.
Yeah.
And then what do they do with all this weed? They just burn it in a big bonfire at the end of the year or something, or like what do they do with like 400 pounds of weed?
So generally, at least the official story, I've never gotten to see it, but they. Supposedly, after the pendency of the case, they burn it all, like in an incinerator. So
They
it's
don't
not like
like
outside.
Stand over the fire.
There was like a movie called Homegrown, I think, from the early 2000s, where everybody stood around the fire, like right on the other side of the fence, and got high. But no, it's not like that.
And the lead investigator was Detective Najelski. Remember that guy?
I do.
He was quite a character. I think he actually tried to fight me in the evidence room in front of the prosecutor.
It was pretty close.
I don't know what this guy's problem was.
It was pretty close. I from my memory, you posted something on Facebook that was like, hide your kids, hide your wife, because there was an internet meme going around at the time.
Yes.
And you were like, hide your kids, hide your wife, Oakland County Nets serving search warrants or something like that, which was clearly a joke.
Like clear a joke, and also my First Amendment free speech. Like, you're allowed to say, you know, like when you're driving and you like flick your brights to let someone know the officer's coming. Like, you're allowed to do that stuff. And I have a good history of warning people about the police. I've had protests where police set up like a seatbelt checkpoint, and me and my friends, I was in college, but we had signs that say like police checkpoint ahead, and we kept playing this like cat and mouse game. And then a couple of cops thought it was funny. But yeah, I posted on Facebook that hide your kids, hide your wife, Oakland County Nets out here signing warrants. But this was like not even related to him. And it had to be at least a month prior. But we go into the evidence room and it's like me, you, Sean Myers, the prosecutor. And this detective comes in like, you think you can just post that shit on Facebook? And I didn't even know what he's talking about.
And he was like in your face.
Oh, he was mad.
Like he was. Yeah.
And I'm just like, dude, chill. It's not a big deal.
Help like calm things down a little bit. Like, hey guys,
No, but I stood my ground. I'm like, yeah, I posted that shit, and that got him amped up. And yeah, but these are like these idiots. Like, why are you so mad over marijuana? Like, you got to chill out, man. But yeah, Detective Najelski tried to fight me. He chickened out, and we had no physical contact that day. So that's a good thing. So, not a very good police officer. And also, let's talk about the investigation itself. So, there was a Stingray used.
So,
tell people what a Stingray is.
Okay, so what a Stingray is, and you know, just to be clear, so we're protected from any libel actions. We can't prove it. because we got the case dismissed before we ever got the chance to really dig into this. But it must have been
So we believe they used a Stingray.
We believe they used a Stingray, and we have evidence that they used a Stingray, but we never. I think it would have blown the case up. So they were working with the DEA in this investigation, and what a Stingray is essentially, there are articles, if you look it up on Google, that would indicate that basically every sheriff's department in the Metro Detroit area has access to these machines. And what they do, it's like a box in a van, and it tricks your cell phone into believing it's the cell tower. But it kind of is an intermediary. So there's your cell phone, their Stingray, and then the cell tower. And so it sort of intercepts the call, but you still make it all the way to the cell tower. And then what they generally do, because they don't want to admit the use of these, and they're not getting search warrants to tap your phone. So they're not getting any sort of FISA search warrant because those have really high bars. You really need to have a lot of evidence to show probable cause enough to tap somebody's phone. And it's a lot of work to go through to get it. And this is sort of an end around. They just can park on the street near your office, like park, across the street from your office. You go to make a call. They see the phone number that the call is coming from, and they're essentially an intermediary where they can listen in. But then what they do to disguise that they ever used it is they say they received a tip, and so they say, like, we received a tip that a drug deal was going to go down at Telegraph and 9 Mile Road. And then that anonymous tip, because there's protections for confidential informants.
Yes.
So it's really hard for us as defense attorneys to find out who the CI is. So they say, like, there's some confidential informant who gave them a tip.
But in this case, why did we believe that a Stingray was used?
So how we knew, or why we believe strongly.
Believe strongly.
Yeah, we very strongly believe is because our client, they intercepted some text messages, and they used quotations from those text messages in their search warrant affidavit. And we knew who the text came from, and we knew who the text went to, because we were still in possession of the phone that sent the text. So we were able to identify exactly who those two people were. And the second person we knew, or we believed very strongly, was not a confidential informant to the police, because we know who that person was and we know the relationship. And there's absolutely no reason he was ever talking with the DEA. And so the DEA had said, we received a tip, and that tipster or CI showed us these text messages. And there was another layer to it, that the way they presented the text messages would have been from our client's phone, as if our client was the tipster. Yes. My client specifically was the tipster, which wouldn't make any sense. My client was not tipping the DEA to himself. And so it became very clear that these were intercepted, and then they were using the guise of that tip to then, and those text messages to then get the whole search warrant in the case. The whole case was almost completely based on those particular messages.
So, this has broader concerns than just civil liberties, government surveillance in general. And I know that there's law being proposed to be able to search people's electronic devices essentially without a warrant if the government declares that you're a threat without going through the traditional warrant avenues.
Yeah. It's a big issue, and this is a big tool that they have to, the really devious thing I think about the Stingray in particular, and it sounds like a lot of what the NSA was doing as well, what's come out about what the NSA was doing, but it's that the nefarious nature is that it's without any oversight. That for example, if Oakland County has a Stingray and they want to listen to Nick Somberg's phone calls, they can just park that thing outside.
Right.
And then if they don't ever, because our Fourth Amendment protects us from the evidence coming in against us at trial, but there's no law preventing them from intercepting your phone call in general. It just means that they couldn't use that interceptor.
And your remedy's exclusion. Your remedy is not money.
Exactly.
Your sole remedy is that we don't get to use that evidence in the crime.
Yeah,
or
and
use
then
the
you have to prove that they illegally, because what they do is they go one down the line. They say they got a tip, and then they find this other evidence over here. And if you can't prove that there was the Fourth Amendment invasion earlier down the line, then you never even get the suppression. But like best case scenario, you get suppression, but there's no, for police officers, at least in the government, for me and you to tap, if I tap your phone, that's a felony. Right. Or if I were to listen in on your conversations, that's a felony.
Right.
But the police get to break the law.
Right. Their government has no consequences.
Correct.
And that's part of why I'm running for Congress, too, is that I think that the law we should have equal protection of the laws. New idea, well, old idea, but it doesn't really exist anymore. And Congress can exempt themselves from laws. The police can, tyrannies when the government can do.
According to our Supreme Court, the president's immune too.
The president does have immunity.
Yeah,
for sure. And that's been there for a long time. In his official
there's a recent ruling that I think extends it a little bit, but I think a crime's a crime's a crime.
It's been because it makes sense. Like, you don't want a president to have to, whoever our commander in chief is, to be like, well, as long as they're acting in their official capacity. So if the president's just going about his business and steals a candy bar from 7-Eleven, I mean, he should have a misdemeanor for larceny under 200. But if it's
but the problem is that acting within an official capacity issue has the qualified immunity specifically. Let's get off the president and talk about police officers, but it's been extended so far. I was reading a case out of a good district, like 9th District Court of Appeals, Federal Court of Appeals, California, right? And the cops basically robbed a bunch of cash from this guy, right? And he was suing them for stealing his money. And how we know they weren't acting in the course of their official capacity is because they got a subsequent warrant for the person's phone, and they said they found whatever it was, $5,000 in cash when they actually recovered $20,000 in cash, and they stole the other 15. And the court said, well, when they took that other 15, they were still acting in the course of their official capacity.
Yes.
So it's I agree with you in the idea, but it's what's the official capacity?
Right.
If I'm a cop and my duty is to prevent murders, and I think this guy's a murderer, and I go up and shoot him in the head, was I acting in the course of my official capacity?
And they get away with it.
Well,
what the case you described was that was a drug case.
Yeah.
So that's another thing. The victimless crime is, I think, if people, I'd have a lot more leeway if police officers were investigating and solving actual crimes, where I'm like, oh yeah, give them a little leeway. I mean, shit, that person might have murdered somebody, or that person, might have robbed a bank or something. But most crimes are like drug possession, driving while license suspended, all this silly stuff where there's not, and and then at sentencing, victim impact statement, blank. Well, why are we here?
Yeah.
I want to go back to what we were talking about, our case, because they found all this stuff, right? They found hundreds of pounds of weed, 7,000 wax containers, and our clients all walked out with nothing, not having to go to trial. At the preliminary exam stage, at the district court, when you're charged with a felony, you have the right to a preliminary exam, and the state has to prove against you. It's like a mini trial, and the state has to prove against you that a crime probably occurred, and this person was probably the one to commit it. So it's a really, really low bar. If somebody shows up to court, if you're accused of robbing somebody, charged, and if somebody shows up to court and says that man robbed me, that's going to be enough evidence for probable cause to go up to the circuit court level. So it's a really low standard. Drug cases were even if the police illegally found, drugs in your car, it's still going to get bound over. Just the fact that they found it, that the search isn't even to be challenged until the circuit court higher level. So we're talking they have literally millions of dollars of marijuana and marijuana stuff that they stole and found. And they couldn't even meet that standard. And how did we do that?
Well, I think there's a few big things. One, I think that what you can see when you really look at it is that it was a biased investigation. I think there were news reports. You can see they really wanted these like headlines about this whole thing.
Yeah.
And I don't think they really conducted a true investigation here.
They were charged with possession with intent to distribute over 45 kilograms, which is our highest marijuana charge. And then not only that, on your sentencing guidelines, if you have 1,000 grams or more, it's plus 100 points. So these guys are looking at prison upon conviction with no criminal history.
And when I say bias investigation, what I mean is an investigation that's like not objective, where that once they had their targets locked in on our clients, they ignored any evidence that our clients were not guilty. And they only looked at the evidence that would support their prior conclusion, so it was a completely biased, right? So what was really going on was this was a bunch of medical marijuana patients and caregivers renting space in a big building. Our clients had an office in that building. There was some evidence in the office that they were cannabis caregivers, legal under the state of Michigan. But instead of investigating everything that was happening in this building, and because I think the truth of the matter is there were some actors and some renters of the space in there that were finding themselves a little bit outside of the Michigan Medical Marijuana Act, but those people weren't our clients.
Right.
But they were just like, oh, you own the building. You're responsible for everything going on in this building. You had an office with weed strain names on the wall. You must be guilty for everything in here. Not to mention, we might have caught some officers being not so truthful, testifying under oath on the stand. Like, for example, there was a safe inside of the office that had a gun locked inside of the safe in a room where there was no marijuana. But they wanted to charge with felony firearm, which is a 2-year mandatory misdemeanor. So they made sure to take a picture of the safe with the door wide open.
Right. That's not how they found it.
And they testified that they found the door just wide open and the gun just sitting there. But, I think there was a pretty fun day. I think we were in your office going through discovery, your old office off Woodward. And we were going through discovery and we noticed like, hey, there's a picture of the safe closed without a huge dent in the corner. And here's this open safe with this huge dent in the corner. That's funny. And what we figured out is, of course, how the officers break into anybody's safe. And anybody out there, if you want to know, your safe's not quite as protected as you might think. You take a safe, you drop it on the front right corner from a high height onto concrete, and it busts the mechanism that opens the door. And eventually we got testimony out, although the original testimony that it was wide open, is that they busted this safe open and basically staged this photo to make somebody look more guilty than they were. And in the end, after we kind of put the screws to them on cross-examination, what we found out is they had never once observed our clients in the building. Our clients had never been observed even touching any marijuana. The marijuana in the rooms where there was some, so what's the evidence they even had any marijuana? Well, there was rooms with a proper number of plants. So they were within their protections of the Michigan Medical Marijuana Act, and they had their medical marijuana paperwork on the wall, like somebody who was following the law would have. And they had absolutely no evidence of them having any connection to any of the sort of illicit marijuana activities, no text messages, no conduct. They didn't try to follow them. They didn't try to find any evidence of a single sale because our clients never engaged in a single sale. And so that's what came out. And so what looked in the paper like this big bust and positive evidence, what the truth was, is they just really didn't investigate it. They didn't care. They were like, we got an office. We have proof that these guys were in this office where there was no marijuana. This is a sexy case because we got some guys, some guys that are businessmen in the community. And it looks a lot better to have the biggest bust in Michigan history where it's 3 guys perpetrating it than a bunch of really tiny busts. And that's really what it was.
Now, I remember one of the officers took the stand, and this was when they found however many pounds were in these freezers. But he testified that that you couldn't smell it, that he walked into the room and didn't know that there was marijuana in these freezers. And it was as soon as he answered my question, he realized that he kind of stepped in it. Well, he thought the question was dumb, but it was well, how'd you know there was marijuana in the freezer? He goes, well, because I opened it. I'm like, yes, because you opened it. Did you ever see my client open that freezer? No. You ever see my client even in that building? No. So they let the genie out the bottle.
Yeah.
They were the ones who tampered with, and they had no evidence whatsoever, you're right, that our clients had anything to do with any sort of illegal marijuana activity.
Yeah. At most, they had compliant Michigan medical marijuana use.
Right.
That's at most.
But this was a big case where but these guys were also like trying to do everything right because they're businessmen. They didn't need the money. I mean, this is like, hey, we want to get in this industry before when it's 100%, black and white, that we're already set up to say, okay, go and have a super successful business. But the police basically took that dream from them. They burned these hundreds of pounds, whatever was done with them. I don't know if they had a big bonfire, but
I think it was burned. And what the thing that bothers me the most, we talked about how it was this biased investigation that they didn't investigate. Like, they admitted they surveilled the place and saw all these other people coming and going from the building, which was clearly there was a renter situation where there was a bunch of different people with their own separate areas, right? And the head sheriff of Oakland County holds a press conference and said, we investigated and determined that there was no one else involved. And it was just these three people. And then plastered their faces on TV. And you can tell that the press didn't contact him. He contacted the press about this one and just went out there and trashed. I mean, I know for my client, this really hurt him. He was a supporter of Sheriff Bouchard before this, and the fact that he goes on TV and says, we investigated and determined nobody else was involved, when it was so clear, for even based on their own police reports, that our clients were not the ones involved and it was all the other people, is just, without the evidence, it just really grinds my gears to this day. Yep. Because although we won, and we won at the earliest stage we possibly could have won the case, they're like, they lost business. Their faces were all over the news. People didn't want to do business with them. They lost, thousands of dollars of investment. They had to all really start over. And still to this day, if you search their names, there's this article that's still available. We just watched it before we started just to kind of remind ourselves, but it's still, so if you search their name, there's still an article. We investigated, determined it was just them. Yeah. And they're guilty. Yeah. Never a retraction, never the county sheriff being like, actually, we didn't even have probable cause. You don't find that. Right. So it really, they're still victims, even though we won their case as quickly as possible.
Yes. They are the victim in the victimless crime.
Yeah.
Well, David, thank you so much for coming on the show. We absolutely killed this case. It was worth talking to people about. And how can people find you?
You can find me rudoilaw.com. And that's my website. My office is in downtown Royal Oak. You'll see a sign next to the Leo's Coney Island in downtown Royal Oak. And if anybody has questions concerning marijuana law or just civil rights in general, I'm always happy to field that stuff. And, although me and Nick don't agree on everything, I think we agree on a lot. And it's always a pleasure coming by and just being able to chat it up. We get in some of the most vigorous arguments with each other, but we always remain friends and
that's important. That's
fight
important.
The good fight together.
I say steel sharpens steel.
Yeah,
right. Iron sharpens iron. So,
all right, peace, man. It's great to see you.
Appreciate you. Thank you for watching this episode of the Liberty Lawyer Podcast. If you like this type of content where we talk about fighting the government, beating them, protecting people's constitutional rights, please subscribe to this channel, like this content, turn on notifications. Also look me up on Instagram and TikTok. And until then, we'll see you next time.